Hello, my name is Lucas Lisitsky, and I'm a student at Osgoode Law School in Ontario. And in this episode of Case Law Minutes, we're going to be taking a look at the Supreme Court of Canada case, Willick versus Willick. Now, this is a family law case that pertains to the subject of variations on child support agreements, specifically whether an increase in the paying spouse's income can be used as the basis for ordering a variation on an existing child support agreement. Now, quick disclaimer, this video is for informational purposes only. If you have a legal problem, it's always a good idea to talk to a lawyer because they'll be able to give you advice that pertains to your specific circumstances. Now, the Willicks were a Saskatchewan couple that got married in 1979. They had two daughters together, but unfortunately, while their daughters were still young, they ended up separating in the year 1989. Now, they negotiated a separation agreement between them that would settle the financial obligations that the father would have towards the mother and the kids. The father was to pay $450 per child per month in child support and about $700 a month in spousal support, totaling to about $1,600 a month from the father to the mother. Now, these payments were subject to a 3% increase every year starting each September. And the mother swore an affidavit that these payments at the time were sufficient to support her needs as well as those of the children. Now, at the time that this agreement was negotiated, the mother had no income of her own, and the father made $40,000 a year as an airline pilot. Now, a few months later, the mother became aware that the father's income had actually increased to $75,000 a year, so almost double what he was making before. Now, 2 years after the agreement was signed, the mother ended up applying to the court to vary that original child support agreement, saying that she was no longer able to make the children's needs with the meager income that she was making now, and that given that the father's means had increased, given that he had had an increase in income, the child support agreement should be altered so that their payments would be increased. So the trial judge decided that that variation would be granted, and the child support payments were increased to $850 per child per month, so about $1,700 a month in total just in child support. And when the husband appealed, he appealed to the Court of Appeal, and that court ended up overturning the trial judge's decision and basically restoring the original child support agreement. And the wife ended up appealing this decision to the Supreme Court of Canada. So there are two big questions before the Supreme Court in this case. The first question is whether, under the Divorce Act, a variation to a child support agreement can be granted on the basis of one of the spouse's income increasing. And the second is, how does the court decide whether a change in circumstances can be used as the basis for a variation pursuant to Section 17, subsection 4 of the Divorce Act? Now, the Divorce Act stipulates that when deciding whether to grant a variation order on a child support agreement, the court first has to satisfy itself that a change in circumstances has occurred since the making of the original child support order. Now, interpreting this provision, Justice Sapinka writes that Section 17.4 states that a change in circumstances of either the former spouse or of any child of the marriage must be demonstrated to the satisfaction of the court before a variation order can be granted. Now the court had to answer the question of whether a change in circumstances is significant enough to be considered the basis for a variation order. And they set out the test that a material change in circumstances is a change that, if it was known at the time when the child support agreement was being negotiated, would have resulted in different terms being arranged. Now, this change in circumstances could be with respect to the needs of the children or the means of the parents. And in this case, it was demonstrably true that the father's means had changed. His income had almost doubled since the time the agreement was negotiated. Now, the court also notes that the purpose of this Section 17, subsection 4 of the Divorce Act is to permit the court to vary a child support order when the relationship between the needs of the children or the means of the parents has changed in some material way. Now, exploring further the relationship between the needs of the children and the means of their parents, Justice Sapinka writes that the goal here is to make sure that children are sheltered as much as possible from the consequences of divorce. This means that if their needs increase, effort should be made to meet those needs, and that children should also benefit from any improvement in the lifestyle of one or both of their parents. Justice Pinka also notes that the means of the parents almost always has an impact on the needs of the children. However, he does also note that there are limits to what children could reasonably expect to benefit as one of their parents' income increases, and that the child support arrangement is not an income sharing scheme. It's meant to meet and maintain the needs of the children, not share income between the two ex-spouses. So in the end, the Supreme Court ruled that yes, the trial judge was correct in holding that a variation of a child support order could be granted on the basis that one of the parents' incomes had increased. They set aside the Court of Appeals decision and restored the trial judge's decision, and in the end, the variation was granted, and the payments from the father to the mother changed from $450 per child per month to $850 per child per month, as the trial judge had originally held. Now, if you'd like to read this case for yourself, you can find it on the Supreme Court of Canada's website, as well as on CanLII. And of course, if you're interested in more videos like this or other videos in this series, be sure to check out the Litigation Help channel and subscribe. This has been Lucas Lisitsky, and thanks for watching.